My name is Jay Katz. Good evening. Thank you for joining us at the Psychedelic Association of Canada's webinar, The State of Psychedelic Law. We're delighted to have you here with us. Some of you are members and have been to many of our webinars. Some of you, this might be the first one. I hope it's a great experience, and I hope that you're looking forward to learning a whole bunch of legal stuff, as I am tonight, the official legal stuff. The Psychedelic Association is Canada's largest psychedelic community. We have over 800 members across the country. Our mission is to educate and advocate to make psychedelic medicines available to all Canadians. We've only been around for a couple of years, but we've managed to get a few things accomplished. We worked with a group of others in the space to get the SAP access approved at Health Canada for psilocybin in medical assistance in dying. We submitted a 14,000 name petition to Parliament supporting plant and fungi medicines. We commissioned a poll that showed that 78% of Canadians approve psilocybin for end-of-life patients. We did an awful lot more, so I won't keep going on and on, but please go to our website, psychedelicAssociation.net, to learn a lot more about what we've done, what we're doing, and how you can be a part. Tonight, you are a part of what has happened in Canada in psychedelic law in the year 2022. One of our panelists, like Marc Goldrub, we want to thank him for writing his annual report. The State of Canadian Psychedelic Law is providing the framework for what we're going to talk about tonight. And we are lucky to have the leaders and founders and experts of psychedelic law from across Canada, experts in drug policy, cannabis law, and now psychedelic law. They're all here to join us so we can talk about the incredible things that happened in 2022 in psychedelic law. And I'm going to let them introduce themselves because they'll do a far better job than I could ever do. And we'll start first with Marc.
Hi, my name is Marc Goldrub. I'm a lawyer at Green Economy Law in Toronto. I think that about covers it. There's going to be more later.
And next, Jennifer, all the way from Vancouver, British Columbia.
Hi, I'm Jennifer Taube. Thank you. It's a pleasure to be here. I'm a federal jurisdiction administrative law lawyer with a focus on psychedelics and cannabis law, particularly in the regulatory and policy side. This involves applications, communications, Section 56 exemptions, federal court applications, working groups, and advice. I cooperate regularly with a group of academics from across Canada and some in the US on issues in the psychedelic space and professional training. Some of those of you who already know me will know that I have been very focused on the opportunity for spiritual care providers to access training in psychedelic assisted spiritual care, as I feel spiritual care providers are underutilized and fill an unmet need, and our overwhelmed healthcare system could use the assistance. I have been cooperating with individuals at University of Ottawa, St. Paul's University, and the Canadian Association of Spiritual Care with a similar vision. And fortunately, they seem to be in the late stages of developing several psychedelic assisted spiritual care related training programs. I'm also interested in psychedelic related religious groups and churches. Thank you.
Thank you, Jennifer. I lost my mouse. I couldn't turn my microphone back on. Next, joining us from Calgary, Alberta, David Wood.
Hello, my name is David Wood. Thank you very much for having me. I'm a lawyer and patent agent. I divide my time between an in-house position at Psygen Industries, where we manufacture psychedelic drugs for use as APIs in clinical studies and for any other authorized research. We're a Health Canada licensed dealer, and we're authorized to manufacture LSD and psilocybin, MDMA, mescaline, and other psychedelic drugs. And we've also manufactured unscheduled psychedelic drugs for researchers. When I'm not working at Psygen or outside of my practice, I'm running my solo practice, R Group Legal, where I provide intellectual property and regulatory advice for cannabis and psychedelics. And I'm building that on my PhD in structural biochemistry, as well as about 12 years of practice at a leading national law firm in Canada. Really, really happy to be here. Really happy with all the developments that have happened in 2022 and look forward to the progress that's been made continuing.
Thank you, David. And then our remaining panelist, Robert Laurie from Nanaimo, BC.
Well, I'm not from Nanaimo, from Vancouver. I live in Nanaimo. My name's Robert Laurie. I'm an international lawyer. I'm qualified in England and called to the British Columbia Bar. My legal practice focuses on commercial business, government, regulatory issues, plus charter and constitutional legalities surrounding cannabis and psychedelic plant medicines. As a lawyer, I've been working to reform drug laws, and as a consultant, I've been advising and devising regulatory policy and business solutions for companies operating globally in the regulated food, cannabis, and psychedelic industries. I serve as a board advisor to the Psychedelic Association of Canada, Last Prisoner Project, and formerly with MAPS Canada. I'm currently an advisor to the Heroic Hearts Project UK and Heroic Hearts Project Canada, and am a founder in the McKenna Academy of Natural Philosophy. There's way more I could go on and talk about, but if you want to learn more about me, check out my webpage at lusamlaw.com or my LinkedIn profile. Thank you to the PAC for having me, and I look forward to tonight's discussion. Thank you.
Thank you, Robert. So now we are going to dive in to the exciting things that happened in psychedelic law in the past year. There were 4 big happenings: SAP approval at Health Canada, the decriminalization in the province of British Columbia, some new regulations in Alberta, and a charter challenge. And so Marc will introduce each one of those topics, and then we'll discuss them a little bit after his introduction. And it looks to be an illuminating evening. So Marc, no more for me, and the screen is yours.
Okay. So yes, all right. The title of this has already been announced. I don't need to reintroduce it. You know you're watching. Okay. So this is what happens when you watch anything lawyers do. This presentation is for educational purposes only. Should not be construed as legal, investing, or any other type of professional advice. Before purchasing, selling, consuming, cultivating, or otherwise engaging in any way with any psychedelic substance or narcotic, please check the applicable laws of your jurisdiction, which are subject to change. Like I said, my name is Marc Goldrub. I'm a lawyer at Green Economy Law Professional Corporation in Toronto. It's a Toronto-based corporate, commercial, and environmental law firm for the new green economy. We mostly work with green businesses and nonprofits, although psychedelic businesses and nonprofits and practitioners are a big part of the firm's work now. I'm licensed to practice law in Ontario, New York. You can learn more about the firm at greeneconomylaw.com. You can email me at mg@greeneconomylaw.com. And if you want to learn about psychedelic law, I run a website called psychedeliclaw.ca, which is all about Canadian psychedelic law. Jay already announced the topics, so let's get to it. First thing we're going to talk about is Special Access Program regulatory amendments. So what happened to explain? In Canada, let's just briefly do a very brief overview of what's legal and what's not and what's sort of in between. Cannabis and ketamine are legal, regulated. There's ways to get them that aren't too complicated. Peyote's technically not criminalized. There's a way to get it also that's not too difficult for, especially for Indigenous groups that make use of it as a sacrament. This stuff, all our favorite psychedelics, psilocybin, LSD, DMT, MDMA, and technically mescaline, even though peyote contains mescaline, these are all explicitly criminalized substances. And then ibogaine and 5-MeO DMT fall into a weird category, which we're not going to explore tonight, but they're not categorized the same as these guys. We have a law in Canada called the Controlled Drugs and Substances Act. This is our main drug prohibition law. It has a provision that you may have heard of called Section 56. Section 56 is a very broadly worded provision that says the Minister of Health can exempt any person, class of persons, any drug from the law. they can provide an exemption kind of however they feel like, as long as they believe that it's for a medical, scientific, or generally public interest purpose. In 2020, Canada began granting medical exemptions via Section 56, allowing non-study participants access to medical psilocybin therapy. TheraPsil was instrumental in pushing this. And when I say non-study, I mean that there were clinical studies making use of psilocybin before 2020. But in 2020, we saw people outside of studies get access to psilocybin for medical reasons through Section 56, through an exemption from the Minister of Health. But Section 56 is not the easiest thing to use, and there's not a clear process for getting an exemption outside of a clinical study. There are forms for exemptions for clinical studies, but there's no form for a medical exemption under Section 56. There's not a clear process. So there was pressure on Health Canada to create something more accessible. And in December 2020, they said, we're planning to amend the regulations governing the Special Access Program. The Special Access Program is a program that's been around for a long time. It allows requests to Health Canada for legal access to otherwise inaccessible drugs in serious cases. Doesn't actually have to be life-threatening. It has to be serious, where other therapies have failed to help the patient or otherwise unsuitable or unavailable in Canada. So here's the key thing. There's a form. The amendments would allow health practitioners like doctors to request access to psilocybin and MDMA for patients with serious illnesses or serious health issues by means of a form submission, better than, just kind of this sort of somehow get in touch with the Minister of Health. These regulatory amendments were expected to make psychedelic-assisted therapy more accessible, but the issue is it didn't. There's just a lot of rejection, difficulty, frustration, and lack of clarity around what Health Canada wants for someone to get a granted exception. And all right, so now we can talk about it. That's my 5 minutes.
Thank you, Marc. Introducing which one of our panelists would like to address SAP first?
Okay, I can jump in. So I would like to add that in the context of Health Canada, that Health Canada's issued dealer's licenses to a number of companies to develop and produce drugs according to GMP standards. And as Health Canada is a regulatory agency, they will have a preference for GMP produced products and regulated business because they're looking for cleanliness, standardization, consistency, and potency, et cetera. So once they were able to create that kind of a line of production, then there would naturally be a preference for Health Canada to enable SAP. And I think, David, you'll probably have a fair bit to maybe add in there.
Yes, absolutely. And thank you for the summary, Marc. So the SAP is, as Marc recognized, a really old program, and it's been around kind of, actually, I don't know how long it's been around. I never looked into that, but certainly it was there in the Food and Drug Regulations the first time I read them. And its actual purpose is for accessing a drug that has not received regulatory approval in Canada, where there's a kind of a 3-part requirement spelled out, but the general gist is it has to be an emergency. Other therapies have to have been tried and failed or ruled out. That's one. And then third, there has to be evidence that it'll work. And I know I've seen it happen with access requests for psychedelics where it's on that third one where things sometimes fall down if you're outside of whatever indications there's real evidence that your proposed treatment will be directed to. And when I say you in that sentence, I mean the physician, because it's important to know when you're when you're the person who has to file a special access program request is a physician. Patients can't file them. So it's always a choice made by a physician, and the physician, in addition to kind of spelling out why their patient needs the particular drug, would also have to give evidence for why that particular drug will help their patient, and then reasons why that particular drug is necessary and why other treatments that may be more accessible have been ruled out. And I know it was really publicized in the media where one patient who I've met actually had been counseled by Health Canada to try electroconvulsive therapy before they tried psilocybin, because there was evidence that would work, and it, I guess, had not been ruled out. Now, it's also important to recognize that in the end, they did give him access, and they did not require that he try ECT. And I suspect if you looked more into that, and I have no particular knowledge of what the communications were between them, but I would suspect that it was simply suggested by the regulator. And then once the physician who'd filed the request replied and said, I don't think that's appropriate, I doubt the regulator pushed back on them. And that's one thing I really want to emphasize is whether it's through my work at Psygen, where we are a licensed dealer, as Jennifer mentioned, or through our group Legal, where I practice with other clients, any interactions with Health Canada have been amazing. They're a great regulator to work collaboratively with, and it's been really, really rewarding professionally to see how open the regulator is to helping Canadians that really need it get access. Now, they don't have unlimited bandwidth, and they do have policies they're constrained by. And unless those policies are reset by, the government and individuals in government who are setting policies, then there's a limit to how broadly they're going to allow use of the special access program to access psychedelics or any other drug. And I'll just kind of pass it on to Rob for some comments with one more point, and that's that the special access program, it's a very old program, and it is only accessed in those three circumstances. The other thing to recognize, it was not made for psychedelic drugs. Like, this is not some sort of psychedelic specific access program. It's just for drugs in general. And I think the kind of archetypal case it's designed for is kind of a rare cancer drug, where if the person does not get the drug, they're very likely going to die, or die much sooner. And in a lot of cases, the drug is already approved in another country. And that happens a lot because Canada is a relatively small market. And while we have a high GDP, especially per capita, we're a smaller market in terms of pharmaceuticals. So if you're talking about a rare type of cancer or some rare genetic disorder that only affects a tiny number of people, the product may not be approved in Canada, but where it's that diagnosis, it might be straightforward, cut and dry, that some rare, expensive drug that's not approved here is the perfect thing to use. And it's situations like that the SAP was built for. And the change that happened just over a year ago on January 5th, 2022, was that restricted drugs, which include that middle column in Marc's presentation, those all became available through the SAP. And when I say those all, I mean restricted drugs generally. There's a lot of them that weren't in the 5 bullets there, but pretty much any psychedelic most people can think of.
So let me just make a little comment on that, because I actually had more slides, but I cut them for time, talking about this issue that, yes, when the regulations came into effect, the amendment said we're now allowing people to request restricted drugs. At the same time, there was a Section 56 exemption granted for practitioners to use restricted drugs in connection with special access program, but it was only granted with respect to psilocybin and MDMA. So when I initially looked at the amendment, I said, why does everybody keep saying psilocybin and MDMA, restricted drugs, DMT, LSD, everything? And then I said, oh, it's because they had to get this Section 56 exemption to allow health practitioners to work with them, and that was only granted for psilocybin and MDMA. And it's also an interesting point that I've heard of a number of SAP applications granted for psilocybin. I have yet to hear of one for MDMA. Maybe some of you have.
The subsection 56.1 exemption that was issued when the FDR were amended was issued because there's far more evidence for MDMA and psilocybin than there is for any other restricted drug. That's why you've seen so many psilocybin requests allowed. I'd be surprised if MDMA were not the second restricted drug allowed. Third, it's either LSD or DMT, and I haven't even heard of anyone trying, but I'm sure we'll see it because they're being actively studied. But the SAP is under the Therapeutic Products Directorate. It's under the Food and Drugs Act, and it's permission to a manufacturer to transfer a drug to a physician, and it's permission to the physician to use it with their patient. That's all therapeutic goods, Therapeutic Product Directorate, Food and Drugs Act, as in drug products. The second part is the Office of Controlled Substances. Even if the Therapeutic Products Directorate gives you permission to receive a drug and give it to a patient because you're a physician, the physician still needs permission from the Office of Controlled Substances to possess the drug because it's a restricted drug, which is a type of controlled substance. So that's why that authorization's there. So if someone did apply for LSD or DMT, they would have to get a specific subsection 56.1 exemption issued just to them, or we might see the Office of Controlled Substance amend the class exemption to include, I wouldn't be surprised that if they saw a lot of data coming up for DMT or LSD or a different drug, that they might add it if it's a restricted drug. Because when you say other drug, unless it's a 2,5 substituted phenethylamine drug or any other, I shouldn't say any other, or any amphetamine drug, it's unlikely to be captured with an expander language. And that means that weird tryptamines, this is definitely not legal advice, but other tryptamines that aren't specifically scheduled a lot of times aren't scheduled and therefore aren't controlled substances. So would be eligible for special access without an exemption and always have been. But you're right, the MDMA and psilocybin have the most evidence. That's why they issued that. But I'm talking too much. Rob, what do you think? Are they giving us enough rights, Rob? Should we say thank you?
Hell no. I mean, you're all fools for playing along. But anyway, my thought on SAP is that, none of this is new in that the conservative government were the ones that effectively put in the former 1.1 in, what was it, Schedule C, David, which prevented from new and experimental drugs. It basically had the prohibition that it was put in place by Rona Ambrose of the conservative government. And as Marc rightly touches on in other analysis and other topics of the PHS case, again, this was one of the heroin along with these other psychedelics were removed from special access and put into that special restricted list. And what surprises me in all of this is how long has Justin Trudeau and the Liberals been in power? Was it 8 years now? It's too long in any event. However, they've only recently, about 6-7 years into their reign, reversed what the conservative government had wrongly put into place. So I guess my concluding comment on SAP is it's a little too late. It's great that it's back, but it shouldn't have been taken off and restricted in the first place. And is it working? Does it seem to be working? Arguably, no. Access isn't coming quick enough. The barriers are too high, which is great because you only have to walk downtown Vancouver or go online to realize that there is an abundance of other access points, which make a lot of this over-regulation and restriction. It's hard to take a lot of it seriously, if that makes sense, given the climate, drug deaths, opioid, and the problems that you're seeing in the downtown east side of Vancouver, which traditionally is where a lot of the grassroots advocacy, from safe injection sites to PHS and other public health and public safety initiatives, which those got us these access points. Unfortunately, there is access now, but it's fraught with problems, and I'll leave it there.
Well, thank you, David. It's actually a fascinating reminder that as important as this work is that we're doing on behalf of psychedelics, it's the latest in a chain of very important moves forward that the public has had to push on its lawmakers, who, despite being called leaders, really are more followers, and they rely on us to push them forward. And it's something that I know you've all been doing for a long time, and this is but the latest and perhaps most impactful on the healthcare system. But let's go back to Marc, who will introduce the second topic, which is the Section 56 exemption for decriminalization in British Columbia.
Okay. All right. Here, decriminalization, BC. What's going on here? Okay. So here's the important thing to start off with understanding. In Canada, criminal law is a matter of federal jurisdiction under Section 91 of Canada's Constitution Act. This is Section 91. It says, here are the powers of the federal government. And we see subsection 27, the criminal law, spelled out very plainly. This is not the case in the US. In the US, states can create criminal law in addition to the federal government. So when we see states decriminalizing things, they have the power to decriminalize at the state level, whatever they want. Of course, if something is illegal at the federal level, decriminalizing at the state won't remove the federal criminalization status, but it will basically just make it so it's kind of an instruction to the state not to direct its legal resources towards something. But in Canada, like I said, it works differently. Just one criminal law. Provinces can't criminalize or decriminalize anything. But what they can do is they can ask the federal government to decriminalize stuff. And in October 2021, BC submitted a formal request to Health Canada for a provincial Section 56 exemption. This is something that I'm not aware of this ever happening before. Maybe one of the other lawyers on the call is going to tell me about some case where this did happen. I'm not aware of a situation where a whole province got a Section 56 exemption. So this request, it's about 40 pages long, and in it, BC says, we think that it would be a good idea to decriminalize basically all personal drug possession up to 4 grams. And they said, we find that criminalization is causing more problems than it's solving. The criminal status of a number of substances leads to a stigma that drug users feel. It leads them to feel fear of confiscation, that they don't want to seek treatment because they're worried that if they go and deal with any kind of authorities, the authorities might lead to their drugs getting confiscated, might lead to arrest. And people are dying because of this. So BC said, we think if the federal government would grant us this exemption and decriminalize drug possession across the province, we would have a much easier time dealing with these problems and saving lives. The federal government in May 2022, a couple of months later, said, okay, we're going to grant a limited version of this request. We're going to decriminalize possession of 2.5 grams, but not for everything, just for opioids, methamphetamines, cocaine, and MDMA. Now, opioids and methamphetamine, this seems like, okay, yeah, that's, that might help save lives. Cocaine, all right. MDMA, I'm not, again, maybe the other lawyers on the call are going to tell me otherwise. I don't know how many people are dying of MDMA, so I'm still a little not sure why MDMA was included here, but it is. The exemption applies for 3 years. It's not just we're decriminalizing it forever. This is still a regulation. It's not a change to the actual law, or it's not even a regulation. It's a decision made under the law by a government agency. So they're not changing the law, but they're giving this exemption and they put a time limit on it. So it will start in a couple of days, and for 3 years, they're going to see how it goes. Now, that's all great, but here's what I find very interesting. Oh, and I made a typo. There's this case called PHS Community Services Society, in which there's a safe injection site in Vancouver called Insight, and it's operating by means of a Section 56 exemption that was granted in 2003 by the Liberal government in power at the time. In 2008, the safe injection sites already actually had this exemption renewed a few times. In 2008, now we're talking about the Harper government, the Minister of Health decided not to extend the exemption, and not extending the exemption basically was effectively shutting down the safe injection site because they wouldn't be able to operate legally without the exemption. The PHS, this is the organization that was behind Insight, BC's Attorney General, and a number of other civil groups all sue the federal government, and they allege, among other things, that the refusal to grant, they allege that the refusal to grant the exemption violates the Section 7 rights of Insight users, and they make the case that the law itself is violating the rights of Insight users. So maybe you've heard of Section 7. Let's actually take a look at what Section 7 says. Section 7, this is part of Canada's Constitution. This is our Bill of Rights, Charter of Rights and Freedoms. Section 7 says everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice. So PHS, the applicants in the case, said, you are going to kill people. By not allowing the safe injection site to continue, you're going to kill them and deprive them of the right to life and security of the person. And we don't believe there's a good reason. The Supreme Court of Canada, they didn't find the argument that the law itself violated Section 7, which is what PHS actually wanted. They said the law itself should be changed, but they said the government's decision not to renew the exemption violated the Section 7 rights of Insight users. They said, we do see that the evidence makes clear that this place is saving lives, and by not renewing the exemption, you are likely to basically kill people. That is a violation of Section 7 rights of Insight patients. Now, here's the interesting question. What happens if after 3 years, we find that BC's decriminalization exemption actually did save lives, that the research comes out and it's positive, but a future government says we're still not going to renew the exemption? Presumably, we're going to have another case similar to PHS. But also, what happens if another province says, look at BC, we want an exemption? What are the grander implications of this exemption? That's kind of the question that I find very interesting.
PHS also stood for the proposition of heroin. They were treating heroin addicts with heroin, right? What a novel concept. And they refused the restricted heroin and put heroin on the restricted drug list, which effectively that was, again, the basis. They couldn't justify withholding the heroin, and ultimately heroin was put then back on SAP, but these other substances are still up. But it's interesting that psilocybin was not included, acid was not included. I mean, when you look at what is pervasive in the downtown east side, really it's kind of a drop in the bucket. But the other thing to remember is what drove and drives a lot of these decriminalization. It comes down to prosecutors and prosecution budgets, because at the end of the day, especially in community court in downtown east side, you might have the same defendant who's been arrested and released multiple times a day on multiple drug violations. And the end of the day, by decriminalizing the small amounts, it reduces the prosecution load and makes for very interesting conversations at the charge approval process in a criminal proceeding as to whether, it makes sense to proceed with a prosecution in the public interest. So a lot of this experiment, honestly, it's kind of like handing out, you know, given the extent of the public health and public safety crises that have been going on, will it actually be effective in curbing opioid death? And is it actually leading to safe supply and safe access? Because at the end of the day, if you're not going to be prosecuted and yet you're possessing dirty, tainted amounts of dirty drugs and hot doses, what good is that as a strategy if people are unable to renew their dirty medicine for clean medicine and exchange tainted paraphernalia for new paraphernalia? By failing to do that, we just compound health crisis. And you look at prison and the court system, it's already over, it's to the brink. I mean, do you have any more room? So really, I think as noble as an endeavor that this is, it really is a method to satisfy one problem by linking it in with another problem. So we'll wait to see how it plays out, but the data can definitely be manipulated if you're able to show, oh, numbers of prosecution and arrests in these particular areas for these particular substances have gone down. You could, more or less say anything. But again, I think a lot of it has to do with government having a safety net or a release valve in the pressure cooker of problems they have to address, with being able to have a bit of room to maneuver with respect to strict enforcement of Section 91 of the criminal law, as you pointed out, Marc. Done.
Thanks, Marc. That was a great summary. The Section 56 exemption really evolved as the municipalities were pressuring the federal government and the provincial government to find a solution, and the city of Vancouver itself applied for a Section 56 exemption. However, they really don't have the jurisdiction to do that. So it was the cue to pressure the province to negotiate.
Well, I mean, so that's, I want to just make a little point. Vancouver asked, Toronto asked, I believe Montreal also asked. They said, we all actually agree. But it was only in BC, it seems, when the province actually asked that there was progress. Yes. But sorry, I'll let you continue.
And there was clearly stronger interest and perhaps more behind the scenes pressures. I can't say, but that was certainly a strong aspect to it. I did find it very interesting that there were certain drugs that were excluded. And I think the rationale is that cocaine and MDMA have been found to contain opioids. And they're concerned that people who consume it may be unwilling to get it tested because of fear of prosecution. I mean, it's a pretty limited exemption. Where it'll take us, I don't know. It's better than nothing. And hopefully those who are those, I think in some ways that occasional users may be more likely to get their drugs tested. And I think it's fraught with difficulties because those who are regular users who may be living in a motor vehicle or a watercraft, in theory, it does nothing for them because they're going to be consuming in that vehicle. But we'll see. It's a start.
I think it's also worth recognizing that in 2020, the public prosecution desk book, and Rob would know a lot more about this than I do, but in August of 2020, the Public Prosecution Service of Canada made it clear that they didn't want Crown prosecutors to push convictions on possession charges subject to extenuating circumstances like possession while driving, possession at a school, and my favorite, possession by a uniformed police officer. That person is supposed to still get convicted. Funny. So that was already a policy, not a law, but definitely a policy. I think what BC's done stacks on top of that, where if it is any of these drugs that are commonly, I didn't say commonly, these drugs that it's not unusual to see them associated with mental health issues, and the BC exemption, as well as the Public Prosecution Service desk book amendment, both recognize that this is often a mental health issue, not a criminal issue. And as a result, it's just better to avoid criminal charges. They don't help anybody. They don't help the person being charged. They don't help society, because to the extent there's a benefit to getting that person off the street, and I'm just saying to the extent that may be viewed as a benefit, it's temporary. All it does, they're back so quickly, and there's a lot of administration and bureaucracy that gets used up on that, and that's people not doing other things. So it's kind of win-win-win not to prosecute on these. And I think my take on the MDMA part is that a lot of times people buy MDMA, and as Cameron pointed out in the chat, not the Cameron I thought he was evidently, but Cameron pointed out that you can get fentanyl in MDMA. And I think that's exactly it. I think if there were another drug that was commonly used, that was commonly contaminated and may be contaminated with fentanyl, if you're a 20-year-old and you're in your third year of university and your friend is reacting in an unusual way to MDMA and you think they might have been poisoned with fentanyl, you might want to feel completely secure in handing over the rest of the MDMA to the paramedics so they can know what's happening and not even worry about getting charged. Yeah. I do think that's valuable.
And MDMA is a raver drug traditionally, right? So do they want to be prosecuting a bunch of adolescents to young adults, and again having people put through the criminal justice system that would be better diverted elsewhere into drug education, drug awareness, rehab, and other methods of dealing with a MDMA scenario that doesn't require incarceration?
Yeah. So it's interesting, there's been a lot of talk about prosecution, and federal government doesn't want to prosecute, a lot of resource on prosecution. Looking through that BC's request, the formal request, is like 40 pages long. So I took the time to go through it, and there's actually not a lot about prosecution in there. It's not in there whatsoever. They do say that one problem this can vary considerably, and a lot of it in the discretion of law. Was just on how drug users perceive the criminalized status of the substances, and the amount of fear that the criminal status of the criminalized status of these substances creates, and what that fear actually leads to in terms of death and health issues.
Thank you. It's amazing how much you learn in a room full of really smart, experienced, educated lawyers with deep knowledge. Thank you for all of that. So should we move on to the next topic, which are the new psychedelic regulations in the province of Alberta?
Yes. Okay. Let's talk about Alberta. So in October, Alberta announced amendments to this very excitingly named regulation, the Mental Health Services Protection Regulation. You can find it online. Looks like this. And they said, we're going to put some regulations for psychedelic therapy in this regulation, and these rules are going to apply to any psychedelic therapy that occurs in the province. There was a lot of confusion about this online. A lot of people thought Alberta was legalizing psychedelic therapy. This is not the case. The regulations do not legalize psychedelic therapy. They do not make psychedelic therapy more accessible in Alberta. But what they do is they at least signal to the world, hey, Alberta is thinking about this, we're ready for it, and we're going to lay down some rules that create a little bit of certainty. I'm sure we're going to discuss more about how everybody feels about this, but that's kind of generally what those rules did. So we've already talked about this. Criminal law is federal. Alberta cannot decriminalize psychedelics for use in therapy. They don't have that power under Canada's constitution. However, they do have the power to regulate professions and trade within the province under Section 92 of the Constitution Act. Online, it seems like most people point to this subsection, Section 13, property and civil rights. As I was taught in Canadian law school, civil rights, as referred to here, does not refer to civil rights like the civil rights movement. It's more trade, regulation, business, kind of general business rights, not the rights of human beings. And you could also point to this Section 16, which is kind of the catch-all provision, all matters of a local or private nature in the province. The province has the ability to regulate these things. So they can say if psychedelic therapy is going to happen in Alberta and it's going to be conducted by healthcare professionals, we can regulate that. This kind of is the key to these regulations, this part of it, saying that clinics providing psychedelic drug treatment must be licensed. They have to appoint a psychiatrist to serve as a medical director. Only a psychiatrist or a trained physician in consultation can prescribe psychedelic drugs. Patients undergoing psychedelic drug treatments must be monitored. So these are very medical regulations that say if psychedelic therapy is going to happen here, this is how it's going to happen. And right now, the only way psychedelic therapy can happen in Alberta or anywhere else is subject to federal permission, whether that's through Section 56 or the Special Access Program. So there was a lot of commentary about these regulations. Some felt that they were overly medical, overly restrictive. Not everybody wants psychedelic therapy to occur strictly in a medical context. In Oregon, you don't need an MD to conduct psychedelic therapy. I looked at kind of the positive side. I'm not saying that those points aren't valid, but I thought that generally this was kind of a good move. But now we're gonna open it up to the room and find out what everybody else thinks.
Perhaps I'll, David, if I could ask you, because you are an Albertan, can I?
Yeah, absolutely. Yeah, I wanted, thank you, happy to. So I am quite familiar with these. I was part of a group involved in advising the government. I'm allowed to recognize that. And it was very informative. But all I'm going to talk about here is the regulations and what they mean. And Marc's exactly correct. These regulations did nothing to change the legal status of controlled substances in Canada, which, as in the first intro slides was pointed out, there's federalism. Like, the government of Alberta cannot regulate controlled substances any more than it can declare war on another country or start up its own patent system. Just like the government of Canada can't tell healthcare professionals in Alberta what to do or what not to do any more than the government of Canada can set the speed limit in Calgary. Like, there's just different scopes of power with different levels of government. And what these regulations do, and I also, I don't like to, I know enough about them and I know enough about the ways this could play out to not judge them as, they're balancing two competing interests here. One is, and that's what all policies do, and all regulations necessarily limit access to something and raise the bar in order to provide access, which I guess is two ways of saying the same thing. And they do that by imposing conditions on providing the, in this case, service of psychedelic assisted psychotherapy or other psychedelic drug treatment services. And there's terms in the regulation. I'm probably using them in a bit of a fuzzy way. I'm probably not using the correct exact terms, but it's something of that nature, like any services related to psychedelic psychotherapy or prescription of psychedelic drugs, which is a little different. But what the regulations do is they require a license at a place, like think a clinic, to provide these services. And in order to have that license, the clinic must have a medical director, and the medical director must be a psychiatrist. And that part is perceived as somewhat of a bottleneck. And, there is a certain rationality to that perspective. But at the same time, we're balancing competing interests here. And and I don't mean competing interests of people or political parties or anything like that, although I'm sure you could line it up with that type of analysis. I just mean the competing philosophical interests of, on the one hand, we want to make sure that everyone who will benefit from psychedelic drug treatment services receives them. That's important. We also want to make sure that people are not abusing this system in order to access psychedelic drugs in a frivolous way, in a way that's not necessarily clinically appropriate, and in a way that might remind some people of the way they perceived medical cannabis. And I'm saying that the way I say it because I think a lot of the criticisms of medical cannabis being used as a pretense to just access cannabis, I think a lot of those criticisms were probably ill-founded, especially when you consider that a lot of those people would have been accessing cannabis anyway, and were in a very real way served in terms of harm reduction by being given a regulated source prior to the Cannabis Act. And I think that made even more sense after it was announced that cannabis would be regulated for adult use purposes. But that's not the case with psychedelics at all. There's no plan to do that. There's no reason to suspect that'll ever happen. And they're really hard to get access to now because the only realistic ways are through special access or through a clinical trial. And I say access as in receiving psychedelic drugs. Permission to own under an exemption is different. And I think those are less likely to issue going forward in any event. But in Alberta, if you can get special access, which means you're allowed to have the psychedelic drug for treatment and you're a physician, you're then subject to these regulations. And my hope is that the regulations are put into effect and actually practically administrated, and that the service standards that are published are realistic enough that a lot of Albertans can still get this therapy, notwithstanding the requirement for a psychiatrist medical director, because in balancing those two goals of maximizing appropriate access and limiting or eliminating inappropriate access, one way to do that is to have a psychiatrist involved. Now, will that actually accomplish the goal? I don't know, and neither does anyone else. We'll see. But I think it is really good that this was done at all, because it shows the government of Alberta is thinking about it. They want to get ahead of it. And let's not forget, the University of Calgary has a chair in psychedelic medicine. Like, Alberta is actually quite strong. I mean, Psygen, where I work, we're here. We manufacture psychedelic drugs. There's a couple different clinics that are based here that are really focused on delivering this type of care, and who will have to, if they're giving ketamine treatment, will have to comply with these new amended regulations. And I think that any criticism of them is too restrictive needs to bear in mind that right now it's really only applicable to ketamine. Most of the clinics that want to provide these services have a psychiatrist. Most, definitely not all of them, but most of them do. And as with anything, we're more likely to see the regulations liberalize than to get more constrictive. And there's already lobby groups, but I don't know if they're per se lobby groups, but there's already groups strongly advocating for moving the requirement from psychiatrists to any medical doctor. And the best psychedelic medicine physicians I've met are not psychiatrists. So I think it's worth recognizing that, including the group that gave the first special access psilocybin, as well as the first subsection 56.1 services, I guess, because I struggle because their patients didn't receive the drugs from them. They had to find the psilocybin themselves. But all that to say is, I don't think at this stage, with the volume we're expecting, we're going to see the requirement severely limit access. I think other things bottleneck access at this point. So if this is a policy that's too conservative, I think the impact to that will be mitigated by the small amount of access that's even realistic right now under SAP. And then the second thing is psychedelics aren't cannabis. I know a lot of people that use cannabis. I know a lot of people that use psychedelics. None of the people that use psychedelics use it the way the people who use cannabis use cannabis. I know a lot of daily cannabis users. I don't know any daily psychedelics users, and I'm not counting microdosing. Well, you hang out with cooler people than I do, but the point is they're used differently. And yes, there were a lot of people who access cannabis medically and just were really happy to have regulated access to something that was not criminal. That was a massive positive in those people's lives prior to the Cannabis Act. However, I think with psychedelics, most physicians who are going to put their license on the line by recommending this treatment are not going to say, here's your psilocybin, call me in 3 months and let me know how it's going, because that's how medical cannabis worked. It was, here's your access, knock yourself out, let's talk in 3 months. But that's not going to happen here. People are going to get access to psilocybin. They're going to use it 3 times with 2 months of psychotherapy, and they're going to hopefully get better. Outside of conditions related to microdosing or conditions, maybe headaches, and there is some provision in the Alberta regulations related to low dosing. I don't think we're going to see many cases made for take-home psilocybin. That's happening in clinical trials, but it's not the same because those people are generally taking very small amounts, which means anyone who's just looking for a way to get their hands on drugs is not, they're going to be frustrated. It's not going to work for them. The way medical cannabis worked really well for those people under that system. So I think the hesitancy around this kind of thing that we see with some more conservative perspectives is because they associate it with cannabis. But I think the use case is so different that the risk that this will be used as a pretext to gain access is, in my mind, close to zero. And if there's any physician who starts saying, I'll let you take home as much psilocybin as you want, if that's even possible under any kind of regulated system, I have a feeling that that would solve itself. I don't know what would, there'd be a complaint to the college at some point. So those are kind of some of my thoughts on it. Happy to come back to it because I am very close to this topic, but I don't want to monopolize this portion of the discussion.
So David, I do have some questions for you because across Canada, physicians have been kind of up in arms about this because it potentially limits their ability to prescribe. And there are physicians who are already treating with ketamine. And so this narrowing of prescription ability to prescribe to psychiatrists potentially has a strong trickle-down effect, and it's concerning. And it means that those who are already accessing ketamine therapies may have less access. So, I mean, that's one of the questions. And the other issue that has been raised is that there were special interests involved, specifically the clinics, that perhaps advocated for the narrowing of access through the psychiatrist. So those are my questions or thoughts for you.
I'll start with the second one. I can't in any way comment on anything that happened at the committees. I've heard that. And if people are interested, they can contact the decision makers of the government of Alberta. They can do freedom of information requests and they can look into it. But I personally can't comment. On the first one, it absolutely will limit the number of clinics and the number of practitioners who are able to provide ketamine for a psychiatric diagnosis, let's say a mental health condition. That is a necessary effect. That's kind of the point. Now, what I'm hopeful for is that the way these regulations are administered doesn't limit access to the point where people that need it cannot get it. And that's where I'm not an expert. I'm not passing the buck here. I'm just saying the thing that's objectively true is there's new requirements. Another thing that's objectively true is some clinics that are providing these services will not be able to meet those requirements. Whether or not that means the patients who need ketamine are not getting it is the part I don't know. And neither does anyone else. You could probably find an expert who would say, of course it won't. There's plenty within geographic reasonable distribution. It just means someone's going to have to go somewhere else in their same city. Then you probably find other people who would say, there's no way there's enough. It's, this is a disaster. People are going to, yeah. And
yeah, access to psychiatrists is already very difficult.
Well, it doesn't. Okay. So the medical director of the clinic has to be a psychiatrist. The prescribing physician has to be either A, a psychiatrist, or B, a physician kind of working with them. So if someone wants to service a lot of people and they're a psychiatrist, they're going to figure out a way that they're comfortable with their liability and their insurance to provide those services and maximize their throughput. Like that, they're motivated to do that anyway. So, and again, who knows if by the time there's more volume, like by the time MDMA is a prescription drug, or mental health treatment has entered a new philosophical area where doctors in general are more comfortable prescribing ketamine or restricted drugs. And when I say prescribing restricted drugs, I mean getting special access, which of course is not a prescription. But if doctors are more comfortable with that and there's more pressure to broaden this, they will. It's a step in the right direction to recognize that it's happening and to get in front of it and to have a licensing system. And regardless of what I think personally about what level of access makes sense, the fact that it's a license that a clinic can get, that means they've been vetted, will make it easier for, say, insurers to decide to cover it. It may make it easier for it to be something people are more comfortable doing, right? Because we're in an echo chamber here. Everyone on this webinar knows a lot about this topic. I'm trying to think of someone who's never even seen a person use a drug other than cannabis. That person who needs help will probably just feel more at ease if they know that this clinic has a special license and that their insurance covers it because of the special license. I could see that being a real upside to this. However, regardless of that benefit, it's really important to get the balance between access and ensuring appropriate standard of care being where it should be. That is very important. And I think in this room, we tend to just assume that that's going to be okay. And it isn't always okay. Like it would be bad to just, I think it would be, to just let anything happen. And, if you believe you understand the experience enough, you can counsel people through it. I don't know. That's not probably a good approach. I certainly wouldn't want to go be an amateur psychotherapist. I have no training in that, and I would be terrible at it. And no matter what my personal experiences are, I think it's dangerous to just say, oh, get out there and do your thing, if you believe you can. I think it is appropriate for there to be a special qualification. And I think for today, a physician or a psychotherapist or whatever the equivalent is in different provinces, that those are the right people. And I think we'll see something evolve that might be a different profession, or it might just be a special part of those professions. Yeah, I don't know. And neither does anyone else. And Oregon will be a good place to see how that pans out. But in Oregon, it is a bit different because you're kind of seeing the product distribution, manufacturing, cultivation part, as well as I'm a professional, I get to do stuff. Those are under the same state head of power. Whereas in Canada, a product, I have no cannabis product handy to hold up. I guess I'm unprepared, but a product is federally regulated. What people do with the product as a professional and how they're allowed to work with it, that's provincially regulated, like in Alberta. And by the way, psychedelic assisted psychotherapy, it's regulated everywhere because it's something professionals do. And it is legal. It's never been illegal. It's legal right now, just like it always has been. The substance may be tricky to get in a compliant way. I mean, these substances aren't even illegal. It's not really a correct way to refer to them. They're controlled substances. Treason and murder are illegal. Controlled substances need an authorization to possess or work with, and your ability Your entitlement to work with them is defined by your authorization. Psygen's a licensed dealer. Psygen can manufacture. Someone has a subsection 56(1) exemption, they can do whatever that piece of paper says, and it'll be narrow because exemptions are narrow. But I'm talking way too much. Rob, tell me everything that's great about Alberta's regulations.
Well, I have to give Alberta credit because everyone was sitting on their hands in BC trying to come up with the perfect approach. And it's nice to see the ice has been broken. And, you know, having lived in Texas as a kid, Houston, Alberta does a lot very similar to Texas, like alcohol regulation, way more in line with how they do things in Texas. So when it comes to regulating an industry and for there to be I guess, a means of creating an industry and having profitability from it, you know, you got to give Alberta credit. Now, will it work in enhancing access, and will it be the greatest thing in psychedelics since, you know, since a bicycle ride? I doubt it. But again, I look at it as a thawing, right? You know, if we were in a hard winter with psychedelics before, we're at a thawing in those regards. But I question, just like we saw in cannabis, are psychiatrists without more in a position to be an adequate gatekeeper with respect to medical therapeutic access? I mean, I'd like to think in theory, psychiatrists would be excellent given their training, again, the experience they have around prescribing medicines, dosing medicines. But I do think that, I mean, come on, like you also have had psychiatrists who have been a huge segment who's spoken against psychedelic use in some regards. So, you know, is it perfect? No, but is it moving to where there's more access in a manner which we could set our watches by? Yes. Will we see anything like this in BC? BC better get moving, because BC usually is in the forefront of these type of things just due to the socioeconomic and political realities of some of the situations we find ourselves in. But BC, you know, is not like Alberta when it comes to creating industry and regulation around healthcare. So, you know what, David? Well done. Congratulations. Carry on and make us all very proud.
So I think Jay, I can sort of get the sense that you're like, all right, on to the next topic. I think I'm right about this. I just want to put in one last point, which I think is an important one. In Ontario, we recently adopted, or Doug Ford adopted, the slogan "Open for Business." That's kind of how I looked at these Alberta regulations. Businesses, and I am primarily a corporate lawyer, businesses like certainty. And I think that Alberta said, you know, how do we get businesses to come and do psychedelic business in Alberta? Well, let's tell them what it's going to look like. So I think they deserve some props for that. I think that's an important point. Anyways, that's all.
Well, thank you. Interesting to hear what everyone had to say about what was a controversial regulation, both for and against. And yes, Mark, my eyes were on the clock. It is time for us to move on to the next topic, which is the Charter of Right challenge coming up through the courts.
Okay. All right, this is the most exciting of all the topics, I think. The charter case for psilocybin-assisted therapy. What is going on here? So, as mentioned earlier, the Special Access Program regulations, the regulatory amendments, have not made psychedelic therapy more accessible. It's still very difficult. Some would even say maybe less. I don't know if I would agree with that, but I'm not as close to it as some other people. But it definitely, people are not happy with it. It's not like, okay, now everything's great. So this case was filed in July 2022. The case wasn't filed by TheraPsil. but Therasol was supporting, they are supporting the case, which has been filed by several patients against the federal government. And they are arguing for an individualized right to medical access to psychedelic therapy, that you should be able to go to your doctor, say, this is what I'm dealing with. And the doctor should say, take two mushrooms and call me in the morning. Not exactly. It's more, you'd actually go and do psychedelic assisted therapy. But the point is, you would be able to do it a lot easier than having to get an application granted by Health Canada by bureaucrats who are not, closely familiar with your situation. Once again, the argument here is being made on Section 7 grounds, saying this is a right people have. It's part of their life, liberty, and security interest, and it shouldn't be denied except in accordance with the principles of fundamental justice. And I always tell people, I say, this case, in the US, this case probably seems insane. But in Canada, it's not, because we've already seen it. In 1996, this guy, Terry Parker, I believe he was living in Parkdale in Toronto. He is epileptic, and he was arrested for possession, cultivation, and trafficking of cannabis, which he was using to treat his epilepsy. And he found that it was really the only thing that allowed him to kind of live a normal life. It's severe epilepsy. So he gets charged for violating the Controlled Drugs Substances Act. And he challenges the law and says, this law, as it's being applied here, is a violation of my Section 7 right. Now, once again, Section 7 says you have a right to life, liberty, and security of the person. And this case goes to the Ontario Court of Appeal. It doesn't go to the Supreme Court. It only goes to the Ontario Court of Appeal, which is the highest court in Ontario. And the Ontario Court of Appeal says Section 7 protects not only your physical health, but also psychological integrity. It protects it free from interference, namely interference by the government. They also said the principles of fundamental justice are breached where the deprivation of the right in question does little or nothing to enhance the state's interest. How does the state benefit by criminally charging a guy for using cannabis to treat his epilepsy? How does Canada benefit from that? We're not persuaded. We do not believe that there needs to be a broad criminal prohibition for cannabis as used for medicinal reasons. It's not consistent with fundamental justice. We don't think that this is a just outcome, that somebody who's just using medical cannabis to treat their epilepsy should be charged and potentially put in jail. And in this case, the government does say he could always apply for a Section 56 exemption to use cannabis. And the court says, no, that's not good enough. That's not a reasonable remedy. So the ruling resulted in Canada legalizing and regulating medical cannabis. And this is a question I've been asking for a couple of years now. If we replace cannabis in the Parker case with psychedelics or psilocybin, don't we arrive at the same result? And that's the question for the group. And that's the last question also.
Let's start with Rob.
Well, the problem with Therasol and the first Section 56 for psilocybin was Terry Parker, who I know personally, was allowed to continue cultivating his own cannabis, and he was allowed to also cultivate cannabis, or he was cultivating cannabis for others at the same time. However, in the case of Therasol, they were granted, or the conditions on their first ticket in August 2020, they could do everything but produce it. So you could destroy it, you could transport it, you could process it, which basically means grind it with honey or eat it with chocolate. But there's no production. And so this is fundamental to, there's similarities, but the government, I think it'll be a cold day before they allow personal production of any kind of a psychedelic. because of, let's not forget that this litany of litigation went on for another 15 years, plus coupled with Justin Trudeau and a federal election campaign to legalize adult use of cannabis. So talk about, a litany of litigation culminating in a perfect storm. But to get to where we got to that point, you got to remember that personal production, good, bad, or indifferent, is what effectively led to the litigation, because patients were producing their own cannabis, and at most of the time the government was restricting access. And I like to say they had to be frog marched toward a invisible line representing reasonable, dignified patient access. We were getting patient access in the Therasil case, but David and others can talk more about it, but where I think Therasil and the case is going to have a huge hurdle is that in 2020, there was an absolute prohibition. Therasil was granted the initial access. However, you now have, unlike in 2020, SAP, clinical access, and Section 56. Whereas before, with an absolute prohibition, there was no access. So, Therasil, in terms of having radar lock and when they should have taken the shot, it was 2 years ago. Whereas now they've got to make all the arguments they would have had to have made 2 years ago. But now, because the door is not, the situation is an open door, even if it's open a crack, it's not shut with an absolute prohibition, meaning the reviewing judges, at least at first instance, will give greater deference, much, much more deference to the government with regards to credibility and weight given to the government's means of restricting or limiting access. So it's a great case. They may be successful, but the opportunity, best case scenario for where you can attack government decision is when there is an absolute prohibition. We don't have that anymore, which I think will make it very difficult in some respects. Jennifer, I'd love to hear your views.
Of course, I'm going back to the mandamus. Individuals who have applied for the subsection 56(1) exemption and have received no reply should really consider mandamus applications to federal court. The mandamus application would require Health Canada to make a decision on the Section 56 sub 1 exemption application. And I consider the mandamus applications as an opportunity to hopefully resolve a client's or patient's outstanding application. But also, if unresolved or unsatisfactory, they are collecting good evidence in support of the chartered challenge. And I think that evidence is important. And as you suggested, because of that little crack, the more evidence that can be presented, the better. And so it's the Section 56 category is not dead. It is still there, and people shouldn't give up on it.
But Jennifer, the problem with mandamus is it's down to government discretion, and that's where, at the end of the day, government are allowed to F it up. They just can't F it up beyond an acceptable parameter where it's ultra vires.
Well, but they do have to make a decision, and the question is, what time frame is acceptable? How long can they take to make a decision? At some point, they have to make a decision. Is it 6 months? Is it 1 year? Is it 2 years? At some point, they have to make a decision. So, and if they're not making a decision, that's what mandamus is for. So, and just another comment. So, for those who are still thinking about Section 56, just to throw it out there, those who believe in access to the whole mushroom, they are not interested in access to a GMP drug. Maybe they believe that psilocybin in its natural form may wish to have access either because for religious or spiritual or psychological or evidence-based or indigenous beliefs, they should still consider that route. Section 56 is not closed. It is part of the CDSA. That's my comment. But the mandamus, I really think it's important. If there are no pressures put on government to make decisions, then you may not get a decision. Nothing, Rob? No.
Oh, I just want to let the others contribute. You know, we could talk about this all night.
So I'll say some more stuff. I've been thinking a lot about this. Perhaps optimistically, I've talked to Spencer from Therasil about this a good bit, and I've also read Canada's defense, like the defense they filed in the pleading, and it was a very unconvincing defense. It was like it came out before we all had access to ChatGPT, but it sounded a little bit like they were like, write a defense to a case here. It was like a very, very lame defense, and it was. I remember there's one line where Canada said the Supreme Court cannot, basically rewrite legislation. I'm like, well, they kind of did that with cannabis already, so I don't know why you're saying they can't. Well, technically, it wasn't the Supreme Court; it was the Ontario Court of Appeal. But the Supreme Court can. They did it well. Courts have done it with other things. We saw it with the euthanasia case, the Carter case. Sometimes I get confused between Parker and Carter, but yeah, in Carter, do you disagree, Robert? Oh, you're on mute.
No, I was disagreeing with something else, but carry on.
Okay, all right. Yeah, so it really was an unconvincing defense. It seemed we're kind of maybe getting a sense, and when I say we, I mean in my conversation with Spencer, that maybe the government of Canada is like, look, we just don't want to deal with this. We're not opposed to it. We would prefer the Supreme Court does it. We would prefer that the Supreme Court tells us you have to legalize some kind of individualized access to psychedelics. We don't want to go out there. We don't want the Conservatives in the next election saying Justin Trudeau wants to give your kids LSD. We don't want that. So we would just like the Supreme Court to handle it. And that seems to be entirely plausible. I mean, it doesn't mean the Supreme Court will do it, but it seems like that might be what Canada would prefer, what the current government of Canada would prefer.
Radio silence. David, save us.
Yeah,
very odd situation where you have a room full of lawyers and nobody wants to, argue. So maybe I did make a good point, Cameron.
I think we're reading the chats and trying to figure out what people want to hear.
Well, and we're getting close to the clock ticking out. I think that as often happens in deep, significant conversations with great legal minds, I end up with much greater clarity and way more questions at the same time. And I think we've succeeded there tonight. And I think that we ended at the perfect point, because I think your question, Marc, went from the purely legal to the quasi-political and partially speculative about what are the true intentions of our government and of our legal system, and what do they?
I would make the case that legal is always political. I don't, I think.
Well,
I don't think you can get away from that.
I think Health Canada has issued dealer's license. There's a whole industry surrounding this. So are you suggesting that we are not moving in the direction of legalization, or because I'm a little unclear, because I mean we're moving.
Is who suggesting that?
Well, I was just a little unclear on the question, because I think the train has already left the station. I mean, we are moving in that direction. Just how long it will take, and in what form Health Canada and Privy Council feel we should take in the end. But the train has left the station. They're already moving towards a regulated system.
Is this, you're talking about a question I asked or somebody else?
Oh, no, I thought that sorry, with you and Jay, the comment back and forth with Jay as to whether we were moving towards legalization or not.
Jay?
Well, I happen to think that I'll sort of answer your question within the limits of my non-legal mind. I think that access to psychedelics is inevitable. I think, as you said, the train has left the station. Is it a short journey? Is it a long journey? Is it a fast one, a slow one? I don't have the expertise to answer that. I think we are in a place of inevitability, and I think that the conversation tonight has been illuminating and fascinating, and much of it within the precise measurements of the law, because the law does its very best to be specific, because that's why it's the law, and that's why you all work so well with it. And when we now come to this curb off which we're stepping that says legalization, it's suddenly non-specific and political and speculative, and we don't know. But the only way I can answer your question is to say that I'm convinced of the inevitability. And I think the conversation tonight has given a lot of insight into the tools and mechanisms that we have to take us to inevitability. We have a few minutes left. I'll just say, does anyone want to sum up? Does anyone have anything really pithy and not too long to summarize our spectacular conversation tonight before we finish it? And so it falls to me.
I wasn't paying attention.
Oh, go ahead.
What was it? Sorry, I was engaged in the chat.
Oh, there's 2 minutes on the floor for someone to summarize our conversation tonight.
There's a lot of work that's been done. There's a lot of more work to go. And if this was a movie, we wouldn't even be past the opening credits yet. And there's a lot more twists and turns that can come before the final act. But honestly, I think it's more or less going to end up being the tale of two cities, exactly what we see now with regulated cannabis, right? You're going to have Newtown, which is over-regulated, very expensive, difficult to access, but you know, the trade-off will be safety and standardization. However, you know, you also have Old Town. It's not going anywhere.
Yes.
So honestly, the two will keep each other in check and allow this space to continue to evolve and grow. But to me, I think these are our birthright, engaging with these medicines and these substances. And with the government getting cannabis so wrong, I'm not holding out a lot of hope that without our help, they're going to get it too right. So we have our work cut out for us.
And thank you for that. That's the perfect segue. That's what the PAC is here to do, is to focus like a looking glass, focusing the sunlight into a fine ray, and to help get the message across, and to help make sure that this inevitable process is done in a way that benefits the most people and makes the most sense. Marc Goldrub, David Wood, Jennifer Tobe, Rob Laurie, thank you all so very, very, very much. It's been a fascinating evening. Lots learned, lots more questions out there. I am much better informed of how our process works and will work to help cannabis forward than I was at the start of tonight. Thank you all for joining us. I'm certain that everyone else got as much out of this as I did, because it was extraordinary. Our next event coming up in February is in partnership with ICEERS, and it's about an update on what's going on with ayahuasca. And we have another event to celebrate Thank You Plant Medicine Day, to meet people and find out who else is in the Psychedelic Association of Canada. Please don't forget to reach out to me or to Cheryl Hanula, our community manager, with suggestions on what you liked and didn't like about tonight, or what topics you might like to see. And I'd like to thank Cheryl and Callie Marr, our volunteers behind the scenes, who were doing all the production for this seamlessly. I'd like to see any Hollywood studio outdo Cheryl and Callie. And it is 1 minute to go, so our lawyers are right perfectly on the timeline. Thank you for living up to that. It's been a fascinating, stimulating evening. Nice to see you all. Marc, thank you for your report. Thank you all for sharing your insights from Calgary and Nanaimo and Vancouver. And we will look forward to seeing you at the next event, which I think is Friday, February 17th, the ayahuasca event. It's on our website. Check it out, psychedelicassociation.net. Thank you all for joining us. Enjoy the rest of your evening.